We are here this evening to commemorate the 50th anniversary of the Civil Rights Act of 1964, one of the most important pieces of legislation passed in the 20th century, and of course it still affects the everyday lives of Americans today. With the keynote address this evening, we will also examine the political leadership of that time frame, especially that utilized by President Johnson as the struggle to get the Civil Rights Act passed took place. We will begin this evening with a panel discussion, and our moderator is going to be Dr. Venters, Dr. Louis Venters. He is an assistant professor of history here at Francis Marion University. He teaches courses in African, African American, and Southern U.S. history, and is the author of the soon-to-be published book titled No Jim Crow Church: The Origins of South Carolina's Baha'i Church. I will let him introduce the panelists. So, Mr. Venters, Dr. Venters, I turn the lectern over to you. I was told earlier it's a lectern, not a podium.
Is that so?
Yes.
Thank you kindly. I guess I have been at a lectern before, but perhaps I was not aware that that's what it was. I extend my welcome as well to everyone, and especially to our three distinguished panelists, whom I will introduce now. Teresa Nesbitt Cosby is an associate professor of political science at Furman University in Greenville, where she teaches courses focusing on constitutional law and racial and ethnic politics. She received her BA and JD from Howard University in Washington, D.C. Before she joined the faculty at Furman, Professor Cosby served as an assistant deputy attorney general in the office of South Carolina's Attorney General, and she also served as the executive director of Legal Services of South Carolina. It's also, I would say, a Great Society program, but enacted under the Nixon administration rather than the Johnson administration. So again, legacies are everywhere. Jonathan P. Edwards is currently serving as the general counsel for Francis Marion University, where he also teaches business law as an adjunct faculty member. Professor Edwards received his BA from Francis Marion University and his JD from the Charleston School of Law. Before coming back to Francis Marion, he served in the Charleston County Public Defender's Office and was a member of several law firms, including his own firm in the Florence area. And finally, Don Fowler received his PhD from the University of Kentucky and began his teaching career at the University of South Carolina, where he has taught American government since 1964. It's a good year. Over the course of his life, Dr. Fowler has also been active in state and local electoral politics. He has served as the South Carolina Democratic Party's executive director and chair, and from 1995 to 1997, he was the chair of the Democratic National Committee. In addition to his adjunct teaching responsibilities at USC, he is also the chair of Fowler Communications in Columbia. So it's my great pleasure to introduce these fine scholars who are going to help us to reflect together about the civil rights movement of 1964. So welcome to all of you first. This is really an auspicious occasion, a good anniversary. We're here to mark the 50th anniversary of one of the most important pieces of legislation. Professor Waters said in the 20th century, I think this ranks up there in the history of the Republic as one of the most important pieces of legislation that we've ever passed. It is entitled, An Act to Enforce the Constitutional Right to Vote, to confer jurisdiction upon the district courts of the United States of America to provide injunctive relief against discrimination in public accommodations, to authorize the Attorney General to institute suits to protect constitutional rights in public facilities and public education, to extend the Commission on Civil Rights to prevent discrimination in federally assisted programs, to establish a Commission on Equal Employment Opportunity, and for other purposes. I hope you will agree with me that for our purposes this evening, we can simply call it by the short form, the Civil Rights Act of 1964. Now, let me state my personal biases. I love this law. I consider myself to be a direct beneficiary of this piece of legislation, and I am grateful for it. I just want to say this at the beginning. For example, I grew up in the heyday of school desegregation in the United States, which was in very large part facilitated by this act. And like many white Southerners of my generation, having black classmates and black teachers from my very earliest years has certainly shaped my understanding of what it means to be a Southerner and an American and a human being. My faith community, the Baha'i faith, had a great deal of trouble finding places to meet before this act was passed. It was already a very racially integrated religious community before the 1960s and faced all kinds of persecution simply for trying to be together in one space, and things were very, very different for the Baha'is after this act was passed. And finally, let me say that my own family would not exist in its current form but for the passage of this act. The piece of legislation that bans racial discrimination in adoption proceedings is actually passed later in 1990, but the Civil Rights Act of 1964 certainly set the direct legal precedent for that other piece of legislation and created the tone in the United States that even made my family conceivable. So I'm indebted to this law in very fundamental and intimate ways, and I'm very happy to be here and to share the stage with this fine panel to discuss what this law meant and means 50 years on. So I note that I'm the only historian on the stage, and I do feel a bit of a burden, but I'll try and make it quick. Right? I want to give a little bit of a background for those of us, well, I wasn't born when this piece of legislation was passed. I look around and I would say that very many of us were not born yet. For those of us who are maybe a little fuzzy about the details of this act, can I just set a little bit of the context? This is one of two pieces of landmark legislation, the other being the Voting Rights Act that was passed the next year in 1965, that represented, in a way, the high watermark of the civil rights movement in the United States, the greatest legal victories for the civil rights movement that was bringing racial prejudice and racial injustice to the forefront of the national consciousness in the years that followed World War II. This law attempted to dismantle at the level of federal law some of the most salient features of the Jim Crow regime. That is the system of white supremacy that was put in place in the South and to a very large extent in other parts of the country as well, just prior to the turn of the 20th century. And the areas that this law specifically attempts to address are the racial segregation of public and private life, discrimination in employment, and restrictions on the right to vote that left the vast majority of black Southerners disfranchised. This law was originally proposed in June 1963 by the administration of President John F. Kennedy, which up to that point had been a rather lukewarm supporter of the civil rights movement. But I should say that the real credit for the bill's introduction should go, I think, not to the Kennedy administration or anybody in Washington, but to the civil rights movement on the ground in the South. The civil rights organizations and activists whose movement to remake this region by the early 1960s was meeting with a great deal of white opposition and often ferocious violence. And this experience highlighted the fact that change in racial matters was not going to come from local and state officials. This movement made it increasingly impossible for the federal government to ignore the citizenship claims of African Americans in the South. And indeed, it was a wave of demonstrations across the South in early 1963. In one week in June, there were 15,000 arrests in 186 cities in the United States, mostly in the South. If it's 186, you can't even call them cities. That would have to include lots of small places, wouldn't it? It's this wave of protest, this wave of demonstrations that culminates with rather extraordinary police brutality against demonstrators in Birmingham, Alabama. Extraordinary even for a pretty violent time. This police brutality in Birmingham was also nationally broadcast on television. No coincidence that it's this wave of protest and the culmination in Birmingham that spurs on the Kennedy administration to bring a bill to Congress, where it quickly stalled. That August, the March on Washington, which every American knows something about, right? Even if we don't know very much about the civil rights movement, there's the famous March on Washington, is called, at least in part, to push for passage of this bill. And then it's finally after President Kennedy's assassination in November, when the new president, Lyndon B. Johnson, made the passage of this bill a top priority, pushed it through Congress, signed it into law on the 2nd of July, 1964. I've mentioned some of the provisions already. It outlawed unequal application of voter registration requirements, outlawed discrimination in public accommodations, that is, any kind of facility that serves the general public that is engaged in interstate commerce. It prohibited state and municipal governments from allowing discrimination in facilities that they controlled. It encouraged the desegregation of the public schools and allowed the Attorney General to bring suits in that regard. It outlawed discrimination by any government agency, any agency that received federal funding. It outlawed discrimination by employers and labor unions, and created the Equal Employment Opportunity Commission to supervise matters related to the field of employment, and several other things that made it easier to take civil rights violations from state courts with all-white juries to federal courts and so forth. But those are some of the big provisions. When we look around the country, when we look around the room today, we see evidences of the work of the Civil Rights Act everywhere. It opened up all kinds of public and private facilities to people of all races. It made room for black people to move into all kinds of professions and at all different levels of skill. When we talk about the black middle class today, we are in very large part talking about results of the Civil Rights Act of 1964, much less African Americans who've risen to levels of particular prominence in public life. There's so much to say about the Civil Rights Act of 1964. I think that'll do, I hope, for an introduction. And I want to turn our attention to the panelists, and I have some questions. We'll see how this goes. I guess the first thing I would like for us to address is more about why this piece of legislation was necessary. Maybe y'all could help us to set the stage in a little bit more detail about what did life look like for African Americans before this piece of legislation? What was happening in the civil rights movement that made this such a priority? Can you help us with a little more of the background and foundation for this discussion? And whoever would like to start.
I think the lady was nominated to go first.
Very well, very well.
So we do have to take somewhat of a glance back to discuss why the civil rights movement, why there was this movement among African Americans and other partners, Jewish Americans, white Americans, other women, who joined together to kind of push the civil rights movement. And you would have to really go back to Plessy versus Ferguson. And it reminds me, when you asked the question, of Charles Hamilton Houston, who was dean of Howard University's law school, who made it his life's career to basically kill Jim Crow. So he's known as the man who killed Jim Crow. And so his understanding was that as long as we had a dual citizenship system in America, that there would never be an opportunity for minorities to kind of break the ceiling and gain full access to all of the privileges of citizenship. So he started a legal campaign, but he started a legal campaign in the 30s at about the time that we have the Great Depression to come about. And Franklin Roosevelt rises to prominence with his New Deal programs. And these New Deal programs were wonderful. They were great programs. But the programs basically excluded from participation in most of those programs blacks and very poor whites. And the way that these programs accomplished this was to exclude from participation in these programs occupations. And the occupations were generally farmers and maids. And those were the occupations that Southern blacks were heavily employed in. Roosevelt had a huge Democratic majority in Congress. So he could get his New Deal legislation passed. But what he couldn't do was break the Southern bloc that demanded that there be local control and administration of these programs. And the demand for this local control was so that the way of life could be maintained. And so during this period of New Deal administration, you had opportunities that were presented to white Americans that allowed them to progress economically in society. You had the comparison of Social Security that white Americans had access to that black Americans did not. You had some employment benefits, but most important was the GI Bill, because the GI Bill was the largest transfer of wealth from a government to a people in the history of the world. And it is what created the middle class. But because of this local administration of the GI Bill, you had this system of exclusion from participation black World War II veterans. And so then you further got this economic separation. And Lyndon Johnson, who pushes the Civil Rights Act, he was an assistant to MacArthur. He'd been a congressman, he was a senator, he'd been in Johnson's administration, he was a vice president, he was a president. So he understood clearly what these federal programs had done, how they had benefited society, and how they had also hurt a certain component of society and set up a system where blacks in the South were horribly poor, and their poverty didn't nearly rank to the poverty of white poverty. It was such a horrific system of poverty, And he knew that by excluding blacks from participation in these federal programs, that this dual system of citizenship was something that the federal government had a huge hand in helping to create. And so I'll leave it there and let someone else join in.
I'll jump on top of that. I think another reason it was necessary is to accomplish something that we had tried to accomplish long before 1964, which is namely to prohibit discrimination by private actors and not just the government. So Ms. Cosby talked a lot about the government discriminating against racial minorities. But there were also, during this era, private businesses, restaurants, hotels, theaters, who were discriminating against African Americans. And we first tried to address this actually back in 1875, in the Civil Rights Act of 1875. And we need to go back a little bit further, I think, to understand that, to the very first Civil Rights Act of 1866, which was enacted shortly after the Civil War, around the time that the 13th Amendment was enacted. So the 13th Amendment prohibits slavery. In the Civil Rights Act of 1866, the most important thing that it did was define what it meant to be a citizen of the United States, which not long before the Civil War had occurred, there was a case called Dred Scott versus Sanford, where the Supreme Court had made clear that slaves or former slaves would not be citizens of the country. And so 1866, the Act defined citizenship, but it didn't do a whole lot else. It enumerated a few very generic rights that everyone had. But in 1875, the legislature tried to prohibit the discrimination that occurred in these private businesses like restaurants and hotels. And problem, though, is that when the government, in this case the legislature, is telling the government what the government can do, that's a little bit easier than when it comes to the constitutional implications of telling a private business that they can't do something with their own private property. And so the basis for the 1875 Act were two of the Reconstruction Amendments, the 13th Amendment, which banned slavery, and the 14th Amendment. And the 14th Amendment said that states couldn't deny citizens of the United States equal protection of the laws or due process of the laws. The 13th Amendment, again, applied to slavery, and so they used that as a basis for the 1875 Act, which prohibited discrimination in these restaurants and hotels, using the rationale that this sort of discrimination was actually a badge of slavery. And the court dismissed that argument pretty quickly and said, essentially, this really is nothing like slavery, and if you go down that road, then you'll end up encompassing almost every type of behavior. But the other rationale for it was the 14th Amendment, which prohibited states from denying equal protection of the laws to minorities and due process. But again, the 14th Amendment says no states can do those things. And so the court said a few years after the 1875 Act, in what are known as the Civil Rights Act cases of 1883, that neither of those were permissible constitutional bases for restricting this private behavior. And again, they pointed out that the 13th Amendment applies to slavery, and that's clearly what it was intended to apply to. And the 14th Amendment clearly applies to the states, and it doesn't mention private individuals or private businesses. But, and this is really important, that in these cases in 1883, the court notes that they were not saying that Congress could not do this under the Commerce Clause, which they had not used that as a basis, but the court made a point of saying that that's not what they were considering. And the Commerce Clause is in Article 1, Section 8 of the Constitution, and it says that Congress has the power to regulate, essentially to regulate interstate commerce. But they had not used that as a basis, and the court back in 1883 had made clear that that wasn't a part of their ruling. And so that's pretty much the way it stayed for until 1964. Now, the Commerce Clause and Congress's ability to regulate private businesses on that basis, there wasn't a whole lot of precedent on it at that point. There were a couple of important cases, but not all that much. And again, the Congress that enacted the 1875 Act didn't try to use that as a basis for it anyways. But during the New Deal era, there were a number of cases under where the court addressed a lot of Roosevelt's New Deal programs that Congress had used their ability to regulate interstate commerce to enact. And in the process, the court had greatly expanded the use of the Commerce Clause to reach a lot of different types of behavior that businesses were engaged in that also happened to be moral wrongs as well. Things like child labor, wage laws, even gambling. And so one of the most important cases that came down was actually in 1942, and it's called Wickard versus Filburn. And that case was about a farmer named Roscoe. And at the time, there was economic turmoil all over the world. And as part of Congress, in an attempt to try to resolve some of the damage being done to the economy, enacted certain legislation one of which was a regulation of wheat production in the United States. And they set a cap on how much wheat a local individual farmer could produce at any given time. And the idea was to regulate, to fix the price of wheat by controlling supply and demand. And so there was this farmer named Roscoe who grew some extra wheat beyond the cap in order to feed his chickens. And it was only to be used on his farm, and it wasn't put into the stream of commerce. And in the case where the Supreme Court was deciding whether or not Congress had gone too far in the Commerce Clause in regulating the wheat that he could grow for his own personal use on his own local farm, the court found, and it found this in other cases too, but this was a particularly important case because of how Roscoe was engaged in this. But they found that if the activity, even if it's local, if you take it in the aggregate, and we imagine what all the other farmers in America, what effect that would have on interstate commerce, if it had a substantial impact on interstate commerce, then Congress could regulate it. And so this case is known as being probably the broadest interpretation of the Commerce Clause. And it's important because it reaches local activity, and because in this case, Roscoe didn't think he was actually doing anything to affect commerce, and it was an indirect effect on interstate commerce. And so when we get around to 1963, and Kennedy's trying to decide the basis for regulating private behavior, if that was possible, that was the most controversial part of the bill, arguably, was this idea that we were going to tell restaurants and hotels and the local theaters what they could do with their private businesses, and that they would have to let minorities come in and use their services if they were generally open to the public. And they went back and forth, and initially Kennedy wasn't too keen on the idea of using this, but eventually they decided to use the Commerce Clause to enact that piece of legislation that would, namely Title II, which tells private businesses that they can't discriminate.
While we're in the neighborhood then, so the Commerce Clause, there were challenges to the law after it was passed, and a few, I think, important ones were even in 1964. Makes me think that some business owners had their cases queued up in the pipeline just in time, right? So was the Commerce Clause, I think, a part of challenging the law, and how did it stand in terms of the court system?
Sure. The two most famous cases challenging Title II of the Civil Rights Act were probably a case called Katzenbach versus McClung and a case called Heart of Atlanta Motel versus the United States. And like you said, they were queued up, ready to file these suits. A lot like Different states were, I think, in the months leading up to the passage of Obamacare. They were ready to file the suits. And the law, as I've kind of alluded to, it addresses mostly restaurants and hotels and theaters and sports arenas and other venues like that. And Katzenbach is a case about a place called Ollies BBQ in Birmingham, Alabama. What happened there is that you had a family-owned barbecue joint in Birmingham, locally owned, and they served barbecue to African Americans only through the takeout window. So they wouldn't let African Americans dine in the restaurant. Now, under the new law, they had to let anyone come in and eat. And so they challenged it, saying that Congress constitutionally was overreaching by regulating an activity that was strictly local in nature and didn't have a substantial enough effect on interstate commerce. And so the court in that case, they ultimately they rule against the barbecue place, and they point out several things. First, when you look at the Wickard versus Filburn case, remember, Wickard wasn't actually putting anything into the stream of commerce, really. And the argument was that his indirect effect was substantial enough when taken in the aggregate with all the other parties doing the same thing. And so the court looks at the fact that, first, we want to know whether or not they have an indirect effect on interstate commerce. But the law also applies to restaurants that serve a substantial portion of food that has moved through interstate commerce. So in Ollie's restaurant, of the food stuffs that it served, about close to 50% of it had been sent from, or they had purchased it from out of state. So they met that part of the law, and they didn't deny, of course, that they were discriminating. And so most of the case talks about the indirect effects that this discrimination was having on interstate commerce. So there was testimony in the Senate when the bill was being passed about these effects. One of the people who testified was the Secretary of Commerce, and he showed that spending of African Americans in those places was much lower when it came to, even when you took into account differences in income. Educated professionals in different businesses from out of states were highly hesitant to move to these southern states where discrimination was happening. And it affected African Americans and other minorities' ability or desire to travel across state lines. So, if you set out for a trip, you're going to go down south to one of these states, if you know ahead of time that no restaurant will serve you food and you won't be able to find a hotel to stay in, then you're not going to travel. And ultimately, there ends up being these indirect effects on interstate commerce as a whole. Now, the other case is Heart of Atlanta Motel, which was a motel, of course, in Atlanta, Georgia, and there was no doubt that they served interstate travelers because that's primarily what a hotel does. And again, the court applied the same rationale in striking down the challenge to it and upholding the Civil Rights Act, that even though they might not have a substantial effect on interstate commerce, when you take all these hotels and all these establishments that are engaged in this activity, collectively they can have a substantial impact on interstate commerce when they are deterring interstate travel and deterring businesses from relocating to these areas.
So there's no successful challenge to the authority of the federal government on that basis to
Yes, yeah, both of those are still good laws, of course. And in fact, the Commerce Clause itself really doesn't get restricted in any way until arguably very recently with the Affordable Care Act cases. Yeah. And so it's just been, since that first Civil Rights Act of 1875 or so, it's just been getting expanded, and it really, the court hasn't taken a chip out of it, so to speak, until arguably very recently.
Very good. And so I imagine we could say that the additional legislation that's on the basis of the Civil Rights Act of '64 is, I mean, I can think of the Americans with Disabilities Act, and I can't make a list of more, but because that precedent stands, then the ability of the federal government to regulate all kinds of behavior increases in the 50 years since then. Why don't we talk about politics?
Well, you gonna give me a shot?
Yeah.
Okay, thank you.
I
First
wanna-
of all, I want to acknowledge the great work that Fred Carter does here at this university. You folks are extremely fortunate to have Fred Carter as president of this university, and you should recognize that and be proud of it.
We know that. We know that.
It never hurts to be reminded of it. Elise Waters is also a great asset to this university, and I'm glad to be here at her invitation. And Elise, thank you so much for everything that you've done. I also want to mention two other people who are and have been extremely helpful to making Francis Marion University what it is. And the first is Pete Hyman, who's long since been dead, but he's the man who really got the state legislature to appropriate the money to put the first institution here as part of the University of South Carolina, and now it's a full-fledged university in its own right. And Hugh Leatherman, who continues to take care of this university in the legislature like almost nobody else does. So those three people, we all owe a very great debt of gratitude for what they have done and what they continue to do. Well, in terms of the Civil Rights Act, let me say that I came to the University of South Carolina in March of 1964, and the Civil Rights Act was passed in that summer of '64. I graduated from high school in '53 and college in '57. Never in my social, educational, or business or extracurricular activities was I ever involved with an African American on the basis of a peer. The first time I ever experienced an African American as a peer in the United States Army. And I was interviewed about 2 months ago when the 50th anniversary of the Civil Rights Act came about by a young female reporter from one of the Columbia news stations, television stations. She was an African American, 26 years old. And I explained to her what the temper of the times were then and how people related to each other. And I used the words, it's a mean and nasty and dirty system. She said, do you really mean that? Tell me more about that. I don't know what you're talking about. This is a 26-year-old African-American woman who never experienced that, and I thought to myself, how damn wonderful that was, that she didn't have to experience that she could hear about it, but didn't have to experience it. It's a dirty, nasty system that we used for so long here in the South to discriminate against almost half of our population, and it held not only the African Americans back, but it held the entire southern region of the United States back. And that's one of the great blessings of the Civil Rights Act of '64, is it released us, it freed us from all that sin and corruption. And that's what it was. The real political change came from World War II. African American men went off to fight in foreign lands. They were shot at, they were killed, they were wounded. They experienced socially not a bad circumstance during the Second World War, because in those other countries they were treated as American soldiers, not as second-class citizens. When they came back to the United States, they came back into a segregated circumstance. Now, I remember all of that. I was alive then. And they said, what the hell is this? We go over there and we get killed, we get shot at, and we come back here and we're second-class citizens. Most of the decent jobs we can't have. We can't go to school in the best schools. And yet we sacrificed ourselves and offered ourselves to this country to fight a war, and when we come back, we're treated like we're part of the enemy. And you know, you just think about that. That's really mean. And it's just amazing that somehow, in some fashion, we didn't realize that until we were made to realize it. Until we were made to realize it. The legal background that really enabled the segregated system was Plessy versus Ferguson, which has been mentioned earlier. In very simple terms, Plessy versus Ferguson said it was okay to have segregated systems as long as you had equal systems. And it sanctioned segregation in every way, in almost every aspect of our lives. That constitutional doctrine was not overturned until 1954 in the in the Brown case, Brown versus Board of Education of Topeka, Kansas. And the Supreme Court said in that case that separate but not equal is unconstitutional. It said even if you had equal facilities, it would be unconstitutional because separation is by definition unequal. And almost every part of the Civil Rights Act and the other advances that we've made in civil rights in this country came as a result of that change in the doctrine of separate but equal. It all relates to the 14th Amendment. The 5th Amendment relates to discrimination, arbitrary action by the federal government. The 14th Amendment relates to arbitrary action by state governments. And it was a separate but equal doctrine that was overthrown in 54 that laid the legal basis. But let me tell you, what happened after the African American veterans came back to this country? They did go to school, they learned, they remember their experience, and that was the emotional, that was the political, that was the social and economic force that they brought to the civil rights movement. And there were no question there were some white people who were involved and who were helpful. But the civil rights movement was uniquely and specifically African American. And all of us owe those people a great debt of gratitude. Most of those people who fought the battle, who won the wars, who did all of the things that were dangerous and necessary are dead. But we all live in the wake of their blessings and what they did. I was on the faculty of the university when the Civil Rights Act was passed in 1964. It was an act that truly frightened a great many people in the South. They truly thought that in spite of Brown versus Board of Education, in spite of all the civil rights things, they thought they could get around it until the Civil Rights Act was passed. And that see, in a court case, if you get a decision in a court case and it says you can't discriminate, that applies just to the people who were parties to that suit. It does not automatically apply to everybody else. So even Brown versus Board of Education applied only to the Brown versus Board of Education in 4 other school districts. It didn't apply to all schools. They had to go back to court, every one of them, and get a separate court order to integrate the schools. And that's crazy. But that's how the legal system works. What happened in 64 was there was a law that applied to everybody in the United States, applied to people in South Carolina, in South Dakota, in Montana, in Mississippi. And that law said you shall not discriminate in specific areas of economic and social life. So that law was monumental. It was in some ways, even more important than Brown versus Board of Education. But it was done through hard-nosed, carefully laid out plans of John Kennedy and Lyndon Johnson. Southern Democrats filibustered the Civil Rights Act of 1964. Some Republicans joined the effort of the Northern Democrats to override the filibuster. And Lyndon Johnson was 7 votes short of enough votes to override the filibuster. 7 votes. He called up his good friend Everett Dirksen, who was the Republican leader in the United States Senate. They were very good friends. There are all sorts of wonderful, funny stories told about those two, but they were very good friends. And President Johnson called up Senator Dirksen, and Senator Dirksen said, well, Lyndon, what do you want this time? Or some equivalent to that. And Johnson explained to Dirksen that he had to have 7 Republican votes in order to override the filibuster to pass the Civil Rights Act of 1964. And first, Senator Dirksen resisted. He said, Lyndon, you know, that really is your fight. I haven't been against you, but, you know, that's your fight. And Lyndon Johnson twisted his arm telephonically and said, Eb, you got to do that.
He did it in person, too. If he could literally get your arm, he would twist it.
He said, you got to do this for me. And he said, well, I'll call you back. And in about 2 hours, called back. He said, Lyndon, you got your 7 votes. And that broke the filibuster, and that's how the Civil Rights Act was passed in the United States Senate.
Well, and thank you for bringing that up. You know, remembering this piece of legislation and other landmark legislation of the Civil Rights era as bipartisan laws and multi-regional laws. It was.
We wish we had that today, don't we?
Well, I thought you might say that. This kind of coalition building was certainly one of Johnson's specialties, and his background in the Congress made him uniquely suited as president to be able to do that. When Johnson signed the Civil Rights Act, he famously remarked to one of his aides, Bill Moyers, and I've heard a couple of different versions of the quip, but the intent of it is, I think we just delivered the South to the Republican Party for my lifetime and yours. And I wonder if any of you or all of you could speak to what he meant by that, and what the political consequences were for him and his administration of pushing this legislation, and the other reform legislation that he pushed, which was not just about civil rights and voting rights, but was about all kinds of things. How did he get it all done? What were the consequences? And how do we, this is a leading question, do we not live with some of those kinds of consequences now too?
We absolutely still do live with some of the consequences. But before I get directly to your question, I want to segue off of something that Dr. Fowler was talking about.
Sure.
And it's kind of that bridge between Brown and the Civil Rights Act passage.
Go ahead.
Because there were actually 2 more Civil Rights Acts between the Supreme Court's announcement and Brown in the 1964 Civil Rights Act. And it's vitally important to talk about that because
57 and 60.
57 and 60. Because Brown standing along, although the Supreme Court says, you know, separate but equal is not constitutional, they had no way to implement that judicial policy. So then you get the Civil Rights Act, and the reason that those Civil Rights Acts couldn't do what the 1964 Civil Rights Act did was because of the Justice Department involvement. And that's critical because now you had a federal agency that is charged to go out and prosecute these cases, and that's the major difference in the Civil Rights Act. And that's why that act was so powerful, because all of the Civil Rights Acts were trying to accomplish basically the same thing, but they lacked that enforcement mechanism at the Justice Department level. And so I think it's important to understand why Brown couldn't do it, but then what happens after the Civil Rights Act is that the Supreme Court, who was now acting on its own, now had the incorporation of the executive branch of the government and the in the Justice Department, and all of a sudden, schools become desegregated. And by the 70s, you've got whole-scale desegregation of the schools, when before passage of the Civil Rights Act, you had very slow desegregation of schools, and it was mainly among the border states. It was not in the heart of the South. So it's important to understand that distinction. But Johnson was, in my opinion, courageous, because he knew he was giving the South away to the Republican Party, but he also understood that if America was going to advance, and I'll let someone else speak more on this part of it, but if America was going to advance, you could not have this dual system, not just because of domestic reasons, but there were international political concerns as well, especially coming out of the Cold War era, as to what America is saying to countries internationally and what it's doing in its own back door.
Certainly.
In the 57 discussion of the 57 Act, Strom Thurmond broke the Senate record for filibuster. He filibustered 24 hours.
Read the Constitution of every state in the Union, and then he still had time left. And, yeah. I think still, for some of the audience, if somebody could explain, like, what delivering the Republican Party to the South for a generation or more doesn't necessarily. What did I say? Republican? Democratic? Delivering the
Democratic Party.
What he said was, we have killed the Democratic Party for a generation, in the South for a generation. It's been 3 generations now, so he was wrong.
He was wrong.
What does this have to do with the changing demographics of the Republican Party and changing strategies among Republicans about where to find votes?
You mean contemporarily?
64 and on, we're dealing with some of the implications of the law. Whoever. Yeah.
The 64 Act did not apply directly to voting.
Correct.
It had some provision, but it didn't apply directly in an immediate sense. The Voting Rights Act of 65 was the one that really contained the muscle that changed forever, or at least from then till now, the way people vote. And what it permitted was very simple. There were all sorts of techniques that the people in charge of the registration and the voting process in the South, all sorts of techniques to keep blacks from registering and voting. Some of them were mean, some of them were subtle, sometimes just many, many ways. And this happened all over the South. And there are some stories that are tragic, but there are some stories also that are kind of humorous because of the ridiculous nature that some of the discriminating acts took. But anyway, what the Voting Rights Act did, 2 big things. One, it said that if the registration or voting officials in any one of the places covered by the Act, and it was mostly the 11 states of the Confederacy, that the federal government, that the Department of Justice could come in and just literally remove the local registrars and put in federal registrars. And the federal registrars would run the system in that area. That happened one time in South Carolina, in Dorchester County, and nobody else ever resisted it after that.
It doesn't take much,
that kind
does
of
it?
discrimination just left.
Yeah.
Well, go ahead. I don't want to talk too much.
Please.
Jump on to that.
That's what y'all here for.
Since we're talking about the politics and how how the Civil Rights Act changed that, and how the Voting Rights Act, which came the next year, helped change politics in the South. I think a lot of people, if you ask them now, you might ask people now, could we pass the Civil Rights Act now? And I think the answer may be no, just because of the way politics have changed, and especially how that coalition building just doesn't exist anymore. And a recent effect that comes from that comes from a case that was decided last year where the Supreme Court actually struck down a portion of the Voting Rights Act. There's a portion in Section 5 that basically says if certain states that have a past history of discrimination that are categorized under a mechanism in Section 4B of that Act, if they go about trying to change the current voting laws, that it has to get reviewed by the federal government. Well, the mechanism used for deciding which states needed to be classified under that system as having a sufficient history of discrimination to warrant that review was Section 4B, and the court struck down that section recently, in just last year, as being unconstitutionally based on outdated data that they got, back in 1965. And so the part in Section 5 that says that certain states can be reviewed by the federal government if they change their voting laws, that's still intact. But the part that changed is the part that classified the states. And so now we have no classification of these states anymore. And so, but again, it's still good law otherwise. So what we have to do now, and what's probably impossible, is for the current Congress to come back and make a new Section 4B, a new mechanism for determining which states now are under this system. And of course, southern states that were trying to change the voter laws were waiting for this decision to come out. And as soon as it did, places like Texas just moved full speed ahead to implement certain voting changes. So,
All of which were designed to keep minorities from voting.
Yes.
Those cases were decided by 5-4 decisions by the Supreme Court. 5 appointees of Republican presidents were for changing those laws, eliminating the Section 5 preclearance clause, and 4 appointed by Democratic presidents voted against doing that. So you see where the politics lies in the Supreme Court. It's pretty easy. But I want to go back to one thing you questioned. I will try to be as quick as I can about this. The adoption of the Civil Rights Act of 1964 probably changed more people's voting behavior and political alliances more than any other one act in the history of the United States. It took place in the summer of '64. '64 was a presidential election year. Lyndon Johnson was going to run for re-election, and everybody knew that Barry Goldwater was going to be the Republican nominee that year. When they voted, Barry Goldwater voted against the Civil Rights Act of 1964, voted against it. In the election of 1964, throughout the United States, something on the order of 93 to 95% of African Americans voted for Lyndon Johnson. Since that election, in almost any election, from local to national elections, African Americans have voted for Democrats in the vicinity, by the range of 85, 90, or 95% for Democrats. It was a change that one vote had that effect on African American vote, and by the same token, almost an equal number of Southern whites voted for Republicans, and they've been voting Republican since then. It was not quite as dramatic or as clear with whites as it was with African Americans, but ultimately other civil rights and related efforts were made by Democrats to provide African Americans with more voting rights and more general rights, so that in that period of time that Lyndon Johnson was certainly correct that this signature will kill the Democratic Party for a generation. And it's been that way. And frankly, there's no indication that it's changing much, except in some few southern states where the population bases have changed since that time. So that's down and dirty politics.
And if I could just add a little more to that, you had the Civil Rights Act, but in between the passage of the Civil Rights Act, you had Lyndon Johnson, who made a speech at Howard University called to pursue these rights. And that was Lyndon Johnson's kind of starting part of his Great Society program that appealed to African Americans. Then you get the Voting Rights Act, which create what scholars call a captured party among African Americans with the Democratic Party, and then this kind of mass exodus of Southern whites. But you still see the impact of that today because African Americans remain a captured party within the Democratic Party. But now because of Hispanic and Asian immigration into the country, you're seeing a hugely changing dimension to voting. And that voting is ultimately going to impact South Carolina because South Carolina right now leads the country in Hispanic immigration into the state. And so now you've got a capture party of African Americans. You got Asians who supported Barack Obama at 76 to 77%, and Hispanics who supported Barack Obama at 76%. And so you've got this division now that's in the state where you've got minorities and women particularly supporting supporting the Democratic Party, and then you kind of have that old Southern bloc supporting the Republican Party, so it's creating a challenge to the Republican Party. Whereas today, the Republican Party can win some elections, but you kind of have to wonder what's going to happen 10 years down the road or 20 years down the road when the total demographics of the country and the state changes.
And I'll just mention on top of that that in terms of people who voted for or against Barack Obama, she mentioned Hispanics and Asian Americans who voted about 3/4 and for Barack Obama. The amount of white males that voted against him was actually close to the same amount, about 70 or 70% maybe.
There are a couple of areas of implications of the law that I wanted to touch on in the few minutes that we have left. One that we haven't talked about at all is an insertion into the language of the law kind of at the last minute of the word sex. So as originally conceived, the law was about ending discrimination based on race, color, or national origin. And I have actually read some conflicting accounts of how this happened, and maybe y'all could shed some light on this, that an otherwise pretty conservative senator from Virginia inserted this word sex.
It was put in there to be a poison pill. It was put in there
So that more people wouldn't vote
Right.
for it.
People would say, that's so ridiculous, we're going to vote against it, when otherwise they were didn't for it.
The story is that when Howard Smith, that's who you're talking about from Virginia, was a known segregationist, and that when he got onto the House floor, I think he was in the House,
Chairman of the Rules Committee.
proposed that sex be included. And what we're talking about is particularly Title VII, which deals with employment discrimination.
Yeah.
And the story I've read is that everyone started laughing. And part of it was because, from what I've read, is that he had this reputation for being a segregationist, for being someone who didn't favor equal rights for anyone else other than white males. But also, in 1964, probably most of the legislature did think it was laughable that they would extend these rights
Except for the
to
women.
women. Except for the women, right.
Strategically the women, because the
Yeah.
women took it up and pushed it.
But it was meant to be a poison pill.
But backfired rather significantly, as the bill certainly did
It took several
pass.
decades for it to backfire.
Well, so in terms of implications, would anyone like to say anything about, so maybe it's language that just got slipped in and wasn't ever intended to take effect, but it certainly did take effect.
But it took effect because the women took advantage of the joke and created a campaign to keep it in. So it's not by happenstance that it stayed in. It was taking this lemon and making lemonade. And honestly, some of the campaign to keep it in was racist too. It was like, how can you give blacks, who would include black women, more protection than you give white women? So that was some of the argument. And there were some women who pushed back on that argument as well. But you had all of these arguments. But the point is that women in the legislature said, no, now that we got this little joke thrown at us, let's make it stick. And so out of that came these huge benefits for women.
When that was done, a majority of women voted for the Republican candidates as a general rule. Beginning with that and going through several other pieces of legislation that affected the status of women, that predominantly Democrats favored and predominantly Republicans opposed, now more women, a majority of women are Democrats, the majority of men are male. I mean, it was the beginning of not a revolution, but an extended evolution of politics in behalf of women. So that's correct.
Are there any other implications that were perhaps unexpected? Did the law do all that it was supposed to do? Did it do anything that it wasn't supposed to do?
Well, it didn't cover voting, but we've covered that.
Okay, so yeah, so
Well-
voting rights is one thing that was left out and required subsequent legislation. Was anything else left out? Could this law have
Well,
gone further at the time?
Yes, because the EEOC was weak, was a weak agency.
The Equal Employment Opportunity Commission,
Yes, the
yeah.
Equal Employment Opportunity Commission, which was created out of the Civil Rights Act, which was kind of the entity that was going to be like the Justice Department and kind of have teeth in this area. That entity did not get the enforcement power that it needed through a lot of political maneuvers. It just didn't get, I mean, even now today, if you have a case and the EEOC is pursuing the case, they mainly are a mediation entity. It's like they'll mediate a case and try to make the case go away. And so they've never gotten that type of power. They've coalition built with civil rights groups and other activists to try to get things to happen. But as far as that entity having the power that piece of legislation originally designed it to have, that never came to fruition.
Disabled and disadvantaged people were not covered in 64, and then we've had subsequent
And then
legislation on that.
Certainly.
also as part of the sex discrimination in employment, it didn't cover enough of situations that women faced when they became pregnant when they were working. So we had I forget the name of it, it's basically the Pregnant Discrimination Act that gives women more definitive rights when it comes to the situation where they become pregnant while they're working.
I also think of the Fair Housing Act that came in 1968, kind of the last bit of race-related civil rights legislation. Anything that we're going to talk about the Johnson administration and the Great Society some in just a little bit. Before I open up to questions from the audience, anything else that you'd like to add?
Well,
right now?
I mentioned the Second World War, and this is not exactly on point, but the Second World War was probably the most seminal period in American history, because out of that Second World War came the motivation, not the reality, the motivation of the Civil Rights Act. It was motivation for women, because women went to work, guys going off to war, got their own pay, they did what they wanted to. It created the seeds of the female revolution a couple of decades later. And the GI Bill has been mentioned, but the Second World War put millions of people. There were 125 million people in the United States in the Second World War. 10% of the entire population, mostly males, but 10%, 12.5 million were in the military. And they got to go to school, they got to see the rest of the world, it changed their view of the world, and they got education, has already been mentioned. And the Second World, technological changes were just unlimited. So in all of those areas, the Second World War developed and prepared this country for an incredibly progressive period of time for decades afterwards. The Second World War was a terrible experience, but God is kind, I guess, to his children, because there were a lot of good things that happened to this country that would have taken much longer to happen if it hadn't been for the war.
Thank you.